We turn now to a famous case in which the Supreme Court upheld a state statute against a challenge based on privacy rights. This is a case you weren't assigned to read. It's Bowers v. Hardwick from 1986. The state law was a Georgia statute criminalizing sodomy, which is defined as any sexual act involving the sex organs of one person and the mouth or anus of another. The next few slides contain graphic, sexually explicit images of sodomy. No, I'm just kidding. The statute provided a maximum sentence of 20 years in prison for a single act of sodomy. The Supreme Court, in a 5-4 decision, held that homosexual adults have no fundamental constitutional right to engage in consensual sodomy. In his opinion for the majority, Justice Byron White implicitly makes an argument similar to one we already examined in connection with contraception. We can reconstruct it as follows. If there's a fundamental right to do X under a certain provision of the Constitution, then virtually all states have permitted individuals to do X, at least since that provision was ratified. It's not the case that virtually all states have permitted homosexual adults to engage in consensual sodomy since the relevant constitutional provisions were ratified. Therefore, homosexual adults don't have a fundamental constitutional right to engage in consensual sodomy. Respondent Hardwick also makes an argument that doesn't presuppose that he has a fundamental constitutional right to practice sodomy. It goes like this. If a law restricts individual liberty and the state has no rational basis for it, then it's an unconstitutional deprivation of liberty under the Due Process Clause of the 14th Amendment. Georgia's sodomy ban restricts individual liberty. Georgia has no rational basis for the law. Therefore, Georgia's sodomy ban is an unconstitutional deprivation of liberty. How does respondent support the third premise of this argument? Here's a crude presentation of the argument for the third premise. Georgia asserts that most Georgians are morally opposed to homosexual sodomy, and that this constitutes a rational basis for the criminal sodomy ban. The fact that most residents of a state are morally opposed to a practice does not constitute a rational basis for a criminal ban. Therefore, Georgia's assertion does not constitute a rational basis for a criminal ban on sodomy. The Bowers majority rejects the second premise, noting that many laws are based on notions of morality, quote unquote. The court refuses to declare the moral condemnation of sodomy to be irrational. Bowers was a very controversial decision, lamented by progressives, libertarians, and supporters of what's now known as the LGBTQ community. But it remained the law of the land until 2003, when the court resoundingly reversed itself in the case of Lawrence v. Texas, which you were assigned. In this case, a gay man again challenged his sodomy conviction as a violation of his right to substantive due process under the 14th Amendment. The law in question was a Texas statute that made deviant sexual intercourse between members of the same sex, but not between members of the opposite sex, a misdemeanor. As it turned out, the court didn't rest its argument on that disparity in the statute. Instead, the court issued a broader ruling. The court cites an emerging awareness that liberty gives substantial protection to adult persons in deciding how to conduct their private lives in matters pertaining to sex. According to Justice Anthony Kennedy, the state of Texas has not presented a sufficient rationale for banning deviant sexual intercourse between consenting adults acting in private. Kennedy doesn't actually assert that there could be no sufficient state rationale for such a ban. What we know is just that Texas didn't present a satisfactory rationale at the time. Legal scholars have concluded that it would be difficult, if not impossible, for a state to articulate a rationale for such bans that would satisfy the Lawrence court. Justice Scalia, in his dissent, accuses the majority of disingenuity. The majority declines to recognize homosexual sodomy as a fundamental right, but invalidates the Texas statute anyway. This makes no sense, according to Scalia. The most widely accepted test for the existence of a fundamental right is that the right is deeply rooted in this nation's history and tradition, quote unquote. On this test, there's no fundamental right to sodomy, as the majority would agree. However, the majority concludes that the Texas law is unconstitutional nevertheless, because there's no rational basis for it. Here's a reconstruction of the majority's argument. If a law infringes the right of consenting adults to engage in sexual activity, and the state has no rational basis for it, then the law is an unconstitutional deprivation of liberty under the Due Process Clause. The Texas ban on deviant sexual intercourse infringes the right of consenting adults to engage in sexual activity. Texas has no rational basis for the ban. Therefore, the ban is an unconstitutional deprivation of liberty under the Due Process Clause. Scalia himself rejects the third premise. But his more interesting claim is that even the majority fails to endorse its implications. He claims that even the majority doesn't really endorse the broad constitutional principles from which they claim to reason. We can reconstruct Scalia's argument as the following reductio ad absurdum. If the Texas ban is unconstitutional, then at least some other morals laws are unconstitutional. The Texas ban is unconstitutional. Therefore, at least some other morals laws are unconstitutional. Scalia mentions examples of laws criminalizing bigamy, same-sex marriage, adult incest, prostitution, adultery, fornication, bestiality, and obscenity. Scalia rejects the conclusion of this argument, intending it as a reductio of the second premise. The majority drafts its opinion in a way that suggests that they too reject the conclusion of this reductio. One could, of course, take a libertarian position against all morals laws, but the Lawrence majority doesn't. They don't mention other morals laws, nor do they mention, much less reverse, any precedents upholding such laws, nor do they attempt to distinguish the Texas law. Scalia concludes that the second premise is false and that Lawrence is, accordingly, a constitutional mistake, even in terms of the majority justice's own commitments. The following hypothetical reinforces Scalia's point. It's similar to ones in the literature. Imagine it's 2004, the year after Lawrence was decided. An adult brother and sister are involved in a long-term romantic relationship that includes consensual sexual intercourse. The sisters had a hysterectomy, so there's no danger of pregnancy. They're convicted of criminal incest. They challenge the constitutionality of the state law, citing Lawrence v. Texas. Could the court distinguish the incest case from Lawrence? As Scalia emphasizes, Lawrence does not contain any argument, much less a sound one, for distinguishing such cases. Yet the majority doesn't even suggest that other morals laws are unconstitutional, or that any prior cases are inconsistent with Lawrence. Liberals who don't wish to challenge incest laws could look for constitutionally relevant distinctions between the incest hypothetical and the facts of Lawrence. The cases differ in two basic respects. The brother and sister are siblings. Tyrone Lawrence and his partner were unrelated by blood. The siblings engaged in sexual intercourse. Mr. Lawrence and his partner engaged in sodomy. However, it's hard to see any constitutional significance in these distinctions. Incest has long been criminalized in all states, but sodomy was once criminalized in all states and was still criminalized in many as of 2003. Incest is widely regarded as immoral, but so is sodomy. Certainly, sodomy is enjoyed by millions and plays a vital role in millions of intimate relationships, whereas adult incest is probably rarer by several orders of magnitude. But why should that matter? If sodomy loses popularity, will banning it become constitutional again? Siblings who copulate may have serious psychological problems for all I know, but will banning sodomy become constitutional again if sodomy starts causing such problems? Perhaps incest between two infertile adults has more negative effects on other people than sodomy has. The parents of incestuous adult siblings usually experience emotional distress, for example, if they learn of the relationship. But so do parents who learn that their son is gay in many cases. So do parents whose offspring marry outside their faith or race. This can't be the real issue either. Think about how someone might defend the Lawrence court's reasoning in light of the arguments I just rehearsed.